From a ringside view of the Indian environmental legal order, we now, in the third module, ease into the core area of the inquiry that begins with the environment protection and pollution control laws. This is the focused area of environmental law, and perhaps much of whatever the common man would understand by way of law concerning environment, it is this area of law that is his area of attention. And that's what precisely we are going to do now. In this session, we will be discussing the overarching law, the Environment Protection Act. Before we get into an analysis of the Environment Protection Act, it is very necessary to look into the National Environment Policy as the starting point of the understanding of this body of law. The National Environment Policy was made in the year 2006, while the Environment Protection Act came into existence in 1986, 2 decades before this. The question arises, why the policy comes later and the legislation is earlier? What should be the sequence? How should we really understand and relate the policy with the law? Well, to put it in simple terms, ideally speaking, with regard to the lawmaking on any subject, we start with a societal problem. There's a societal problem which has acquired a lot of importance and that has caught the attention and imagination of the lawmaker. They deliberate over that to resolve the problems associated with that particular subject. They think of formulation of a policy. What is a policy? A policy is a kind of commitment on the part of the political leadership that, look, we are seized with the problem, and in order to resolve the problem and make things easy for the people, we are coming up with a set of principles, a set of programs of action, and we would allocate so much of funds budgetarily. We will make available personnel for giving effect to those actions that we contemplate under this. So in a way, a policy document is the steering wheel of governance, indicative of the directions the administration should take to reach a desired goal. It does not work that way when we actually look into the logical evolution of something into law. First you have the problem, followed by formulation of a policy, and this would lead to an enactment, a legislation, because policy is not law. Policy actually lays down the first principles of governance, but that is not operable by itself. You do need a tool or a device to bring that into application, and for that you envisage a legislation. So, problem, policy, legislation, institutional arrangements to give effect to what has been stated in the legislation and work it, implement it, and then the expected result is what has been intended. That's the logical sequence of things leading to the problem and resolution of the problem in the legal order. But it does not happen that way all the while. Many a time, for a number of reasons, the lawmaker may be in a hurry to come up with a legislation first. Then after a little while, he will start reflecting on it and then come up with a policy pronouncement. And then later think of an administrative machinery. And then think of a budgetary allocation as and when the resources are made available. But it depends upon the kind of priorities that the policymaker and the lawmaker would have to decide on the course of events this way. When it comes to environment and environmental law, it's a very interesting development that not everything begins with a policy. In fact, we already had the laws in place, the laws in relation to pollution control made much earlier, 30 years earlier, and then the laws in relation to environment as a whole made 20 years earlier. Then comes, all of a sudden, it pops up as a policy document, the National Environment Policy. There is both an advantage and a disadvantage. If a policy is evolved at first, you clearly know the direction in which you should go. And ideally speaking, you should start with a policy and then go to a law. But it does not work always that way. That the law may precede the policy, and through a bit of a trial and error, the policymaker would arrive at a conclusion that the kind of law that we have made needs some improvement, certain refinement or anything. For that, let's lay down a set of policy directives as to how we should go about governance and then bring in changes in the law. So there is no set rule that the process should be like this, and definitely in relation to environment, it did not happen that way. The logical sequencing was not there. We had enacted the Water Prevention and Control of Pollution Act in 1974, the Air Prevention and Control of Pollution in 1981, and Environment Protection Act in 1986. Worked it for 2 decades, and in 2006 came up with a National Environment Policy. Now, what does this contain? This particular document, as it makes it very clear at the outset, that it is something which is a consolidation and a crystallization of a host of policies that were evolved with regard to different sectors of environment. There is already a policy concerning water, a policy concerning forests, a policy concerning abatement of pollution. And so these sectors of natural resources and environmental governance were already having sectoral policies. These sectoral policies were put together, and building upon that, a comprehensive policy statement came into existence to bring in commonality in the approach to various sectoral and cross-sectoral approaches to environmental management, which would definitely include the economic approaches, the developmental approaches, the human rights approach, the scientific approach to environmental management, about which we are already familiar with. So it is something like giving to the rest of the world a clear statement, an assertion of India committing to make a positive contribution to all those international initiatives that are taking place concerning environment, and we get it reflected in the body politic in India. We want to have clean environment. We would like to give effect to the constitutional command of not only the state becoming the public trustee, but also the people becoming environmental stewards, so that the people could be participants in, partners of, and share responsibilities in resource governance in India. That was the basic aspect of the policy document. So the idea was to mainstream environmental concerns in all our developmental activities and act as a kind of a guidebook of action in regulatory reforms, in coming with programs and projects for environmental conservation, and also to have a quick review of all the laws that are made, of all the policies that we have in place, and then come up with proper, effective legislative prescriptions. So the dominant theme of the policy is, while conservation of environmental resources is necessary to secure livelihood and well-being of all, the most secure basis for conservation is to ensure that the people dependent on particular resources obtain better livelihood from conservation than from degradation of resource. All the major environmental principles that we have already familiarized ourselves with, and the strategies of governance about which we had reflected upon and approaches to environmental management are incorporated in this policy document. Now, with this at the backdrop, let us just get into an understanding of the framework law, or the enabling law, or the overarching law called the Environment Protection Act. There is a background to this. What was the provocation for making of this law? The primary provocation comes from something that happened just a little over a year and a half before this act was passed. The worst environmental industrial disaster the humanity ever knew, ever got prepared to, happened in India, and that is the Bhopal gas tragedy. A tragedy of mammoth proportions where so many lives were lost, but for generations, the after effects of this tragedy was being experienced, and it is still being experienced even after 35, 36 years of this particular accident that happened. It was called an accident, it was called as a negligent act, it was also called as an act which was about to take place, and there was every indication that necessary precautionary measures were not in place and the disaster would occur any time. And it did happen on the dark night of 2nd December 1984. The Indian legal order was in complete disarray. It did not know, it was totally clueless as to what to do with the disaster of that proportion. So many people suffering, the environment getting contaminated to that level. For generations you will take time to clean it up, and whether there is any solution in the law which would really take care of the problems there. You have something on pollution control, but will they be adequate enough? And it was felt that it is definitely not adequate. And second thing, that 12 years before this 1984 tragedy that struck us, in the year 1972, we had made a commitment at the global level that we will come up with a very strong overarching law at the domestic level. And time was ticking. 12 years down the line, we had nothing to show by way of a single comprehensive piece of legislation tying together all sectors of environmental governance in one single compendium of a law. The urgency of the matter was further made acute because of the tragedy that struck us, that there are many more Bhopals to take place if we don't really put our house in order. And this led to the enactment of the Environment Protection Act, a very unique piece of legislation, a very small enactment. It does not contain more than 26 sections. An enactment of 26 sections which deals with everything concerning environment. How could that be? Well, we have done that. And it has been variously described as an overarching law, an umbrella law, a framework law, or an enabling law. How do we explain that? What exactly is this law about? It is an overarching law. It is an overarching law because if you look to one of the provisions here, section 24, it makes it very clear that this law has an overriding effect over all other laws, that anything concerning environment, whatever that has been prescribed under this law, is the ultimate word. No other law can conflict with this, could act at variance from what has been stated here, and that way this is overarching. It is overriding. The second thing that you must note, and that's a very interesting position that you see in this provision itself. In the first clause of this provision, it says that this law is ultimate. It overrides all other laws on matters concerning the environment, and this is the final word. But the second clause in the same provision states, but supposing on any environmental issue, if there is a problem, if there is an offense for which certain kinds of penalties are prescribed in this law and also in so many other laws, then whatever that has been stated in those other laws will operate, will prevail over what has been stated in this law. What do you mean? An overriding law should mean that whatever that has been stated here, if it is 100 rupees fine here and some 10 rupees or 5,000 rupees fine in another, this 100 rupees will operate and nothing else. That should be the case. But the drafters, in their wisdom, made it clear that whatever the penalties that are prescribed in the other laws would be applicable in a situation which is actually dealt under this statute also. Why did they say so? They said so for the simple reason that this is a new law that we are creating, and this new law would come up with some penalties, all right, but in terms of the intensity of the impact of an environmentally unfriendly act, as addressed in a very specific piece of legislation, it may be concerning water pollution, will not be there in this body of law, and so we will allow whatever that has been provided in the other laws to operate because they are far more effective and we facilitate that to happen. Please remember that this is not just an overarching law, but this is also a facilitating law. This is also an enabling law. It would enable other laws to work more effectively. And so it puts to center stage the penal sanctions in another law to come into application, in spite of the fact that there is something that has been mentioned of the same aspect under this law as well. Then why mention anything at all in this law? Please remember that this law is also described as an enabling law. Enabling? Enabling, or making it possible, giving an opportunity, creating a space for what? For action. Those other laws that are there in relation to environment, certain sectors of environment, might not have provided for penalties and criminal action for certain of the violations which are actually in environment unfriendly acts. In such situations, they should not throw up their hands and then say, sorry, the law does not provide for that, we cannot act. Here is this law which gives you an additional tool, an additional penal sanction. So in addition to and over and above whatever penalties that you have in that law, we provide you for penalties for those uncharted areas of offensive acts for which punishments are prescribed here. So that way, it's a very unique law which is both an overarching, overriding law, but also an enabling law. In addition, this is a law which also provides certain additional tools of implementation. Many a time, like it happens in the case of pollution control boards, they're created under the pollution control laws. There are situations where, on a number of issues, They may not have the equipment, they may not have the facility, they may not have the procedures under that law to act. And if time is in the essence, that you should act fast. You cannot just go up to your superiors for directions or anything like that. You have to act. Or you cannot bring in a court action and then wait till the court judge decides in this particular case and then act on that. It may be necessary that you need have to act immediately. This is the law, the Environment Protection Act, which provides that additional tools. That's why it's also called as an enabling and an umbrella law, an overarching, an overriding, umbrella, framework, and enabling law. Hardly we find any law in India as comparable to this body of law, which has all these attributes and much more. I said that this law has only 26 sections. Will these 26 sections capture everything? No, it doesn't. In fact, one of the critiques that has been there on this particular piece of legislation was that this is a law that was prepared in a hurry. It was time to act after the Bhopal gas tragedy, and so they came up with a very broad outline of a law in 26 sections, which is actually a little bit of pollution control law put in a different form, a consolidated version of it. But while doing so, they provided a scope for creation of rules, regulations, and notifications. The standout feature of this law is that the statute of these 26 sections, which went to the Parliament for approval, even the rules and orders that are to be issued under that and creation of authorities under this law needed to go to the parliamentary scrutiny. Normally, the statute or the act is made by the Parliament or the state legislature. Rules, regulations, and notifications and guidance documents are prepared by administration. It is an administrative handiwork. But here, even the rules are elevated to the status of the provisions of the act, which require the parliamentary scrutiny, review, and approval. That means it has so much of importance that they have the same status as the statute itself. Normally, the rules are subordinate rules, subordinate law. But here, the rules and regulations have the same effect as the Protection Act itself. The Protection Act protecting the environment itself. So that way, in one particular case, the Supreme Court has laid down that even the rules and regulations made under this have the same status as that of what has been provided in the statute, and so you cannot pick and choose and then say the statute says something, the rules, and it does not provide for certain situations, rules provide for those additional situations, and we are not bound by that. Rules have the same status. That means these rules have the same overriding effect, the same enabling effect, the framework effect, the umbrella effect as the Environment Protection Act has. This was laid down in a very important case decided by the Supreme Court, also known as the aquaculture case. S. Jagannathan versus Union of India, decided in the 1997 by the Supreme Court, that the rules and notifications under this law also have the same status as what has been prescribed under the Act itself. The Act has another enabling provision. The penalties that are prescribed under Section 15 of this Act are for contravention of the provisions of the Act, the rules that are made thereunder, the orders passed under it, and even the directions issued under it. So the reach and the extent of application is huge, wide. A very wide net is cast on that. So in terms of the scope and extent of this body of law, it applies to the entire India. Every conceivable aspect of environment is covered: water, air, land, their relationship amongst themselves, their relationship with human beings and other living entities and property, issues of pollution, degradation. You have specific provisions which actually describe what is environment. So all these come under the pale and purview of this law for protection of environment. The peculiarity of this law: this is a prescriptive law, and it is not a law which has an institutional mechanism of enforcement of itself. As a general rule, every legislation will have an institution of enforcement created under it. Like under the Forest Act, the Forest Department. Pollution control laws, pollution control boards, like that. Revenue law, revenue administration, like that. Each and every law will have its own institution of enforcement. You call it as the administrative body. Interestingly, this law does not have an administrative body of its own. Then, how do you enforce this law? That is the uniqueness of this law. The administrative architecture of this law, let me explain, is kept very simple, more like a framework. At the apex level, you have the central government, which will have its regional offices in 4 or 5 places in different parts of India. And then there is also an authority constituted by the central government in the form of what is called as the Central Pollution Control Board. We will be seeing about its function a little later. That is all the structure here. The structure of governance that has been provided under this law is the central government and its regional offices, only 2. And neither the central government nor the regional offices enforce this law. Then the law that has been made under this is enforced through a number of authorities created by the central government from time to time under this law. So it's a very dynamic thing. It is not a set idea that for this law only one authority. For this law, many authorities may converge, or the same authority may perform a coordinating function, may act as a pointsman, and then get so many other people to work for him. And so that way, in terms of the reach, the scope and extent of the operation of this law is pan-India. All over India, it is operative, and this law is worked not by a single agency of state, but by a number of agencies. Then what do the central government and regional officers do? They are more of a brain trust, policymakers and lawmakers, nothing more. Law implementers are those are the authorities who are constituted by the central government. In a case decided in the year 1995 by the Supreme Court of India, the Indian Council for Enviro Legal Action versus Union of India, the Supreme Court stated that the central government has a very wide power under this act of creating any number of authorities. It can even make one individual as an administrative authority on a particular area of implementation, and they will get all the powers under this law to enforce this law, that aspect which has been assigned to that particular authority.